let me ask you a few questions.
Sure.
You ever do an OUI trial?
Have I done one? Yes, many.
Okay, do you know how the prosecutor puts a police officer on the stand and they ask him about these things called school sobriety tests?
Correct.
What's allowed officers to testify to that? To show the ability to drive a car safely?
Right.
You ever read any books or read any publications to show the correlation in driving a car safely, walking 9 steps with the trunk?
Haven't found them yet, Counselor.
Ever heard of any books or publications or studies done on whether or not saying the alphabet is correlated with driving a car safely?
I have, including saying the alphabet backwards, which sometimes does.
So, if there's never been any studies, because I've asked every single police officer that I've ever done in 40 years, trial work, tell me if they've read it. No, can't give me one. No studies. So, my question to you is, why are they allowed into court if nobody's accepted it in the scientific community as being shown to be a correlation in operating?
That's a great question, Counselor. When I started at the DA's office back in 1989, 1990, they were allowed in. They continue to be, as you well know. But I certainly would agree with you in terms of the correlation between taking those field sobriety tests and whether or not you are operating under the influence. There doesn't seem to be quite that correlation.
Well, I know they allow them in. I know you will allow them in your court, but I have to think of that weight to give them as far as evidence. No, us humans usually have to do things more than once to get right. A lot of times people that are stopped on the highway, a couple of police officers, cruisers, they're upset, nervous, escape. I mean, just think of if you ever get stopped for going through a stop sign, the police officer comes to your window. You can never find that goddamn registration in the glove box. So on these stops, though, they use that against somebody. Couldn't find the registration right. Had to go through a little wallet to find their license, like somehow. That's bad. So I just asked you to think of that before you make a decision.
I will.
You ever do any trials jury waived?
Yes.
Now, there's some criticism about that, and there are forms that we fill out, we call conference forms.
Green sheets. Yeah. Green and iron.
Well, the pre-trial conference form on the back of it's got a question whether or not you're going to have a jury trial or a judge trial. You check the box. And some of them even say if it's going to be a judge trial, you can waive the jury right here and now. If you fill that report out and send it in. You ever have a judge do that?
I actually have that. I certainly, and they're not the green sheets. The green sheets are for the disposition, but for the pretrial conference reports, I typically always fill out jury. There certainly are cases where when it finally winds its way to trial, even that day, that for one reason or another, I feel it's in my client's best interest to waive the jury. I've never had a problem. I understand that perhaps occasionally that can be a problem. I personally have never had that problem being able to waive the jury at that time.
So if Judge Rooney's sitting on the bench and a lawyer comes up and says, we'd like a jury waiver trial because they have heard that you're a fair man. You say the word not guilty. Okay? And you go, oh, yeah, but you checked off the jury box. You got to have a jury trial. Would you make the person go for a jury trial?
I would not.
There are judges who do that at this time.
Yes.
So what I write in the back of those forms is unable to make a decision at this time. Because how could you ever make a decision not knowing what judge you were gonna get in a month, 3 months when you come up with the trial, right? And they said, well, that's judge shopping. And I said, well, isn't it my duty as a zealous advocate for my client? Judge shopping?
I see nothing wrong with judge shopping. I mean, it's done every single day, I would say, in every district court in the Commonwealth. When you walk in, at least in the Springfield Hall of Justice, the courtroom 2, where the pretrials are, that's the first question everybody asks each other. Not how are you today, and who's the judge? There are advantages or perceived advantages or disadvantages that various lawyers bring to that. I see nothing wrong with judge shopping.
And 6 of the Supreme Judicial Court judges sit on our benches. They told us, they sat in that chair, that it would be ineffective assistance of counsel for you to waive it out without knowing the judge.
That's absolutely right.
So, you know, you've been around the courtroom long enough, when we go into courtrooms, we do ask who the judge is. Or in an unfamiliar court, we ask the next question. How is he in jury waive trials? Right?
Yes.
Some people go, forget it. Never gonna happen. So Judge Rooney's sitting there, what am I gonna hear from people?
Well, you certainly, I would hope that you would hear, you can consider waiving that jury, you'll get a fair trial.
So I guess.
Sometimes we ask for more, but that's all we should expect.
Yeah, but you want somebody that's, and usually lawyers in the business that know the business don't usually jury waive if it's a case that is slammed down the loose. You just don't make a judgment decision. So usually the jury waives, for the most part, are iffy cases, right? You know there are judges who don't ever say it. I don't know how they got here.
I'm sure, but
But
there
you know
are some.
something? They all sat in that chair, and guess what they all told me? Oh, Counselor Jubenville, I'm gonna be able to do it. And they go out in the field, and they sit on benches, and I stop in the courthouse, and I see somebody there, and I go, how's this, person doing? Terrible. What happened? Somebody once said to me, an old timer said, it's the rope. It chafes the back of your neck and it irritates. So put a little something behind there so that it doesn't happen.
I will if I'm confirmed.
Okay. Now, you think there's a lot of judges that are putting people in cages, as I call them, because they fail a urine test for no other reason?
And just so we're clear, when you say cage, you're talking about in the jail as a
I don't
probation
call them
officer.
jails anymore. I call them what they are, cages. You know, when I was a kid, I used to go from Hoyoke over to the Forest Park Zoo. You ever go there? Well, I remember as a kid, cages with lions in them and tigers going back and forth in these cages. And then a big cage they had, I think in the middle somewhere, they had a whole bunch of monkeys in the cage. You know, we don't put animals in cages anymore. So, I don't call them jail. Cages. So, you think there's judges that put people in cages for the sole reason is they feel
Yes, I mean, it obviously it would depend on other circumstances, but and what other probationary conditions they may
I'm
be
just
on.
talking about feeling.
I think for the simple failure of a urine test, yes, there are some judges that view that as a violation that deems going to jail. I think
You think putting people in jail is helpful to somebody who's
I would say Definitely not. I mean, there could be other circumstances, that there's violence or things like
I'm
that.
talking just about.
If it's just that, no. I think hopefully we know more about addiction today. And hopefully we have judges today that know more about addiction than perhaps was the case 5, 10, 15 years ago. But there are still some. But do I think it's helpful?
So everybody says that. So, you know about addiction, you know that relapse is part of recovery. It's a natural part. So, the judge once said to me, well, I put him in jail. Put the fear of God. And I said, well, that tells me that I don't know a goddamn thing about addiction. Because addiction will always trump fear. And I remember a case in Hampshire one time, where a police officer, Myron Preacher, his brother was a very bad alcoholic, 5 kids. Very tough police officer. He beat his brother half to death. Now, he said, if you drink again, so even that could stop. So think of that when you have a probation officer or a DA saying, fuck you. Okay. Programs don't throw you out of the program. Court system throws you in jail. Someday we'll not treat it as a medical condition in our court system.
I think we are making progress through these, certainly drug courts and some of the other things, but we have a
Yeah.
ways to go.
Everything's helpful. When you go through a drug court, you fail the urine test. So what good is the drug? When you have one or two people ready. Everybody seems to say it doesn't help. Attorney Brady said something about he had an issue with a lawyer, you discuss that issue with the setting bar from chambers. You ever put a lawyer in lockup?
I couldn't imagine a situation where somebody's actions, that I would consider somebody's actions requiring that seems beyond me.
Once you do that, it's your reputation. It's not good. Done out this a few years back. Now, have you ever done any dangerousness hearings?
I have not.
So you know about them.
Oh, sure, yeah, 58 days, yes.
Yeah, so the Commonwealth just files a motion. The person's up to 3 days for dangerousness. You think they're overused, or
I actually, I'm a little hard pressed to say that they're overused, because one of the things I tried to do in the last year or so is even follow cases where the Commonwealth has moved for a dangerousness hearing. I've actually gone and put myself in that courtroom so that I could view it, and they never seem to come to fruition. I actually did see one, Judge Charles Gross had one in Springfield District Court. That's the only one I've seen. So, at least in my anecdotal experience, I wouldn't say they're overused. It's not what I've seen.
you know that there are even dangerousnesses found, and set conditions if you feel those conditions will protect
Yes,
the people involved in the society.
that's right.
You wouldn't be adverse to putting somebody on a bracelet.
If the situation warranted, I would certainly look at other conditions.
You ever done any courts here?
When you're saying the first hearing, you're saying like a show cause?
Yeah.
Oh, yes, yes.
You've been around the courts for how long now?
5 years.
You ever see these secret courts going on? Big story in the local secret courts in the town. So
Must
I
be
haven't
very
seen any in 40 years, and I'm continually looking.
I haven't come across.
And they said 8 people had indicated they were treated unfairly in those hearings. They said they had done 62,000 hearings before this article, 2 years before this article. So that means 62,000, 8 people complained. That's pretty good bat average.
So they track.
And in those rooms is always a police prosecutor or DA.
Right.
And if they don't like what's done, they can appeal it, right? Nobody's whispering things in the clerk's ears.
I haven't seen it.
I'm amazed that they couldn't find thousands of people who come in and say, you know, my son had done something wrong. We got the clerk's here. I'm gonna hold this for a year. See how you do. My son recovered, became a policeman, fired. He's flying a jet for the Marines. That wouldn't happen. You think there's a dress code in the court?
Do I think there should be?
No, there is.
No.
So, a lot of people don't have money to show up. Down on the luck. They show up to court. So when I see judges taking off, I'm flying. Court, waiting from their think to myself, can't even afford fees. Speaking of fees, there are certain fees you guys can waive.
No, if the situation warranted, I actually been very thankful that I've had a number of clients that, some that I can represent pro bono that just can't afford the fees. I make a pitch to the judge, and more often than not, the judge will waive those fees. So I certainly wouldn't need those fees.
Yeah. I think some judges think that they're really worth it. We waste more time, in my view, on having to arrest people that didn't pay a fee, getting the police involved, all the money. I was in a court once, not too long ago, 4 people on a road. The judge said to himself, "Did you pay your attorney fee?" I said, "No, it's a lot of work." It's happened 4 times. I looked at the judge, and I knew him before he was a judge. And I said, "You didn't make any money before you were a judge. Now you're collecting money at the revenue, which these poor people don't pay. You can't pay it no matter what. You're locked up." Be kind to the citizens. You're going to pay a good salary, good medical plan. Just remember who's paying you all that.
We will.
Thank you very much.
Thank you.
Thank you. Anyone else? Any Casey?
Good afternoon.
Good afternoon.
I have a lot of questions. We spoke this morning.
Yes.
And I did receive a couple of calls, very positive calls, one from Judge Ed McDonough, with a tremendous amount of respect for, who's appeared before this council on 2 occasions and received unanimous votes in each instance, so it's pretty well regarded in this chamber. We just asked you about your philosophy about the Second Amendment, because in your capacity, if you are confirmed as a district court judge, could very well be dealing with either denials of LTCs, revocations of LTCs, suspensions, and the like. Tell me what your experience is with those issues and what your philosophy is about the Second Amendment.
Well, let me start with my philosophy on the Second Amendment. It's the law of the land. And certainly in 2008, the District of Columbia versus Heller case, followed by in 2010, the McDonald case, which is the city of Chicago. Both of those cases are by the Supreme Court, made clear that there is a Second Amendment right, individual right to have weapons. So that certainly, as I said, that's a settled matter as far as I'm concerned.
Let me just stop you there.
Sure.
We would say that as people who read the law and cases and respect the United States Supreme Court decisions, but our own Supreme Court, in a relatively recent case, the Commonwealth versus Catano case, couldn't understand those two concepts that you very quickly described in less than 10 seconds, Heller and McDonald. And Catano was an 8-0 hearing decision that was kicked back to Massachusetts with some pretty scathing language from Justice Alito, making our SJC look like a bunch of first-year law students, in my humble opinion, particularly the author of Catano. So we say that. So I'd be very curious to hear. I know what the answer is, the law, Helen McDonald, but what is your philosophy about it?
Well, and certainly Catano had to deal with stun guns, but you're right. I mean, the language was
Non-lethal?
not lethal. That's right. But you're right. The language from the opinion from the Supreme Court was very scathing towards the SJC. There's no question about it. I am not a hunter. But again, that's the law, and I would have no problem upholding that. I would. I remember reading somewhere along the way. It's not as if it's not comparable to, for example, a license, a driver's license. That's a right. That's a privilege. The ability to operate a vehicle in Massachusetts is a privilege. The ability to carry a weapon is a right. It's been guaranteed by the Constitution, and as I said, I think the law is pretty settled, certainly from the Supreme Court. So that would not be an issue that I would have any problem with. When it comes to the license to carry, I actually reached out to our chief, Paul Madera, and sat down with him because I actually haven't done a license to carry case. Very familiar with them, but I actually haven't done it. Sat down with him and we had a wonderful conversation about his philosophy and the philosophy of the local police department when it comes to license to carry. And I think certainly when you look at Chapter 140, Section 131, I think it spells it out what things are disqualifiers, and then the district court judge on an appeal would have to find the person unsuitable. I know there's some controversy in the Commonwealth about what one police chief views as unsuitable, the one at the next town or the next county might view as different. So I do think that's an issue that needs to be dealt with. But I think certainly in the hearing itself, if I were to be confirmed and to hold a hearing on the license to carry appeal, I would be looking for as much information as we can bring into that hearing, both from the police department, from the individual, if he or she is represented by counsel. I think it's important to have as much information come out of that hearing so we find out whether or not the person is suitable or not. So that would be my philosophy.
I think that's a good way to describe suitability. Is a very squishy standard. There was a recent SJC case about whether or not the standard itself was too arbitrary and capricious. Just the way it can be interpreted by one chief in this town, by another chief in this town. Well, that's good. I mean, I think everybody should be entitled to a fair hearing, and it sounds like you've taken all the evidence and be fair. And,
Yes.
that's all anybody can ask for. How about restraining orders? What's your experience with restraining orders in any capacity, either as an ADA prosecuting violation, defending people?
Well, I've had quite a bit of experience in restraining orders, 209A orders. They're never pleasant. They're emotional. But I think, again, going back to what I was saying as it relates to the LTC hearings, I think the more information you can bring forward in a hearing on a 209A, the better chance you have to reach a just result. And that would be take as much evidence as you need, both from the plaintiff in that matter and from the defendant. I actually had a case, my last, within a fairly recent period of time, I represented the father, who an emergency restraining order had been placed on him by his 16-year-old daughter. That's when I became involved in the case, and we went in front of Judge Shea in Palmer District Court. It was a long, contentious hearing, but I think it was important to bring out, to protect, in that case, the father's rights, to bring out some of the information. From a personal, professional standpoint, as the father of 3 daughters, I didn't like being there. I was cross-examining a 16-year-old pregnant girl. That wasn't a very pleasant place to be, but I had a job to do. But more importantly, I think the job that Judge Shea did in bringing out as much information took a situation where 8 or 9 days earlier, there was an emergency restraining order granted. And once there was more information, it was determined that the restraining order should be terminated. But I do think, in terms of what my philosophy would be, it would be to bring out as much information in those hearings as we possibly can.
And I think that's important, no matter how busy a district court can, or, is or isn't. Counsel Kennedy's in court every day, and 3 district courts at the same time. I don't have as many clients as him, so I'm only in one at one time. But I think one of the things that happens in the district courts is such a busy restraining orders that are coming in, particularly on a Monday. You might have the overnight weekend arrests, after the holidays, and sometimes things get rushed. And I think, I think that there can be, great injustice done to somebody accused of putting another person in serious physical harm, where you're talking about employment implications, you're talking about legal rights, if this is divorce that's pending or imminent. And I think it's really important that judges, ensure that people get those fair hearings, because it may sound like an emergency at 1 o'clock in the morning on a Friday when the judge gets a call, but after everybody's brought in, the picture is drawn, it's really not.
Right.
Maybe in that case, it was a 16-year-old who got an argument with her father because she was pregnant. And kids today are really smart, and they all have these things which have changed all of our lives in so many ways, always really good. So I think that's really important.
And I think in the case that I was talking about, what wasn't brought up, I didn't represent the father in the emergency order. What wasn't brought up is something that you just talked about, and that is what's going on in probate court. Come to find out, there had been a denial by the boyfriend's mother for guardianship of the 16-year-old girl. That wasn't brought up to the district court judge in the emergency order. Obviously, I brought it up several times.
Was she represented by counsel at the restraining order hearing?
She was not.
The daughter?
She was not.
That would have been something that counsel should have disclosed to the
Right.
court.
She was not represented. Actually, what happened was they left the probate court in Springfield upon the denial and drove right to Palmer District Court seeking the emergency order. But left that information out.
That's true, Judge.
That is, yes.
Yeah, and you talked about the family and probate court, and I saw in your materials you're estimating that you practice in the probate and family court about 5% of your 100% overall practice, which speaks to your intelligence. So obviously, you sent Attorney Brady in to handle that stuff.
Let him handle it.
But there is a lot of there's a nexus there between what a judge may do with a restraining order. It sounds like you're aware of that, and what will go on in the probate court. You have a parent or spouse who's never done a domestic, one runs in, you hear bad advice of counsel, go get a restraining order, you'll get the house, you'll get the kids, then we'll go to probate court, the other side will be prejudiced, there's a presumption against legal custody with a restraining order, and some people can never recover from that restraining order, in litigation in the probate court, so it sounds like you'll be attuned to that, so. Have you done any small claims hearings?
I have.
In defense, plaintiff, both?
Both. I mean, I don't do a lot of small claims work, but typically what happens is when it's a friend, a family member or a friend of a friend, but
So I haven't done a lot of them, but the ones that I have wouldn't just necessarily be on one side or the other. It could be either side.
And I know you were asked a question earlier about, and I have slightly different philosophies than Council Jewel on some of these criminal justice issues. I don't call places of incarceration or penitentiaries cages. Difference I like to say when you use the zoo analogy is that animals are put in cages and they haven't done anything wrong. Somebody's in jail because they murdered somebody, hurt somebody, abused somebody, or raped somebody's child. They've done something wrong. So I have a clear distinction in my mind between an innocent animal and somebody being a performing act. So let me ask you this, just giving you a little heads up there.
Sure.
Do you believe that there are any situations where incarceration can save somebody's life?
Yes.
In the context of this opioid crisis?
I think probably less so, at least in my philosophy, my experience in the opioid crisis situation, because they're dealing with a higher power, and I don't mean that in the spiritual sense. There's something that's driving those people, and I've seen it in my own family. And so the threat of being put in jail isn't necessarily something that has the same impact on folks who are in the throes of addiction as it might be somebody else, myself, or people who aren't in the throes of addiction. But
I don't mean the threat, I mean actual incarceration. So let's say you have somebody before you that's failed 4 urines in a row, they've been on probation, and they look like they walked out that door, probably the last time you're gonna see them, and the family's gonna see them. That's the type of situation I'm talking about. Or a situation where they're before you because they took a brick and they beat somebody over the head to get their wallet, their purse, so they can go get the next place.
well,
That's what I mean about saving.
sure, and that's a big distinction, and I think, I do too. That was one of the things that I tried, I think in my answer to Councilor Jubenville is, we need to know more of the facts. If there's a history of violence, as far as I'm concerned, if I'm confirmed, our main job as a district court judge is public safety. Now, that can have a lot of different connotations, but that's our job. And if there's a situation where somebody, let's say, still in the throes of addiction is being violent, that's a completely different situation than perhaps Councilor Jubenville's example of just failed a urine test. Those are two, I would say, completely different situations.
Just want to end by saying I did read your writing sample, but for what it's worth, it was excellent. As a kind of a nerdy former journal writer in my law school, I like the legal writing. I like the style. I thought it was very well done. And we don't always see quality writing samples. I mean, to this extent, we're all on these, so I didn't want to be remiss in mentioning that. And I think that'll serve you well. Not that district court judges need to write long opinions. Usually it's just denied or allowed at the bottom of the motion. But I always appreciate when a judge takes the time to write a decision out of the district court. I think it's important, and I think it's important to the litigants. Particularly if you have a trial, and not a lot of money in controversy now with the rules, but you get a thoughtful decision from a judge, and even if people lose, they feel like they have to pay in court. So hopefully that will serve you well. That's all I have, Madam Chairman. I'm just going to say congratulations to Attorney Rooney and the family.
Thank you.
Anyone else? Okay.
You've answered a lot of questions. I have to tell you, I appreciate your directness in your answers. I had a very rare no vote today because the nominee that was in here I thought was very indecisive in terms of the way he answered questions. I think that you're probably going to be pretty decisive on the bench. You strike me that way. Just make a ruling, whether it's right or wrong. Just make it move on. That said, Councilor Casey and I don't agree on everything. I have a little different view when it comes to gun control. We need stronger gun control measures. I do agree that the way we do it now is kind of messed up. Just whoever happens to be the chief of police being able to decide whether someone has a permit or doesn't have a permit. Are you gonna always defer to the chief?
No, absolutely not. No, and maybe I misunderstood.
That's what I'm trying to clarify is.
No, the reason that I actually sat down with our chief, I had a couple of other questions, but that was in anticipation of coming today, thinking that that would likely be a question that would be posed to me, because I had never done a license to carry case or hearing. I wanted to get his sense from his point of view, because I wanted to kind of look at what things he viewed as suitable. In terms of, again, and I made reference to, I think it can be an issue where a police chief in Ludlow versus a police chief in Everett may have a different point of view on suitability. I know there's some talk about, well, just let the state take it over. Maybe it goes back to my since I spent a lot of time in public service in Ludlow, I tend to think the government closest to the people is usually the area where we get it right for the most part.
But it should it be a police officer making that decision? It should be some civilian authority making it, even not a local.
Is your question, should it
A lot of
be?
times, there are a lot of police chiefs
Yes.
that I have found err on the side of not giving people weapons whenever there's any type of issue at all. One of the hearings that I did not too long ago was in the prior Chelsea chief of police. I did one in Chelsea court where a person had a conviction for adultery that went back into the 1960s. It's not even a crime denied on that basis. I mean, but there's some chiefs of police just take the philosophy, give them a reason not to give it to someone who put a gun in the street. They're going to deny it.
Yeah, well, certainly when you look at some of the statistics that I've read, about 60% of the hearings at the district court level overturn a denial at the local chiefs. I know in Ludlow, and I think this really is a tribute to our chief, about 80% of the decisions that they've made at the local level are adhered to by the district court judge. But yes, I can certainly understand that can be a problem to have different police chiefs making different decisions and perhaps bringing a different view of suitability to that case.
I think you missed the mark on something that Council Jubal actually did with 58 A's, dealing with probation revocations, where people are held in probation hearing, surrender hearing. When you ask the question, is it something that's overused? You really didn't answer that because you talked about the few experiences you had with whatever court it was.
Right.
Do you think that prosecutors have a tendency to file them too much?
Counselor, I'm not trying to avoid the question, but I don't think I could give you an honest.
Because I can give you my answer.
I'm sure you will.
It's pretty simple because I am in court every day.
Right.
I'm in court every day of my working life practically for the last 35 years. And it is one of the most overused statutes there is. As it is now with probation detention requests, we're locking too many people up when we shouldn't be. So a probation officer comes to you, brings a surrender, somebody's on probation, brings a surrender notice, man or woman has a job, is working, has a family, probably in violation of probation. Maybe you're gonna lock them up later, maybe you're not. What are you gonna do in that situation when the probation officer says, I want him help?
I'm certainly going to hold that probation officer's feet to the fire to explain to me why you want them held.
They violated their probation.
No, well, right, and why it makes sense, given some of
You're on
the.
probation for driving under, okay? A year probation, first offense. You get caught driving to work. You don't have a license. Okay, it happens every day. People have to work and I see that every day. People violate that every day. You gonna lock that person up pending a hearing?
In that limited set of circumstances, no.
Okay. What if it's a second?
I might be wavering a little bit if it's a second or a subsequent offense. But certainly, I think you need to look at the big picture. Again, if this is, let's say it's the
Somebody's
sole
going, in that
breadwinner-
situation I described, somebody's going to jail for 90 days.
Right.
They're gonna be held. Maybe they'll be found in violation at the end of that, maybe they won't. Even if they are, they're probably gonna get reprobated, most likely. I mean, people lose apartments, they lose jobs, they lose their ability to support their families.
Well, and again, that's why I would say I'm going to be very strict, but I'm going to look at that probation officer and I need to be convinced that it makes sense. Yes, there may be a violation, it might be a technical violation, it might be just a violation. I want to be convinced that it makes sense, despite all the things that you mentioned, work and family and apartments and all of that, why it makes sense to lock that person up.
Well, there are some judges that just do it automatic. I know of two that you have a certain violation, we're holding it, automatic.
I would absolutely not be doing it automatically, sure.
How many jury trials would you estimate you've done in your career?
Well,
I know it's tough.
Yeah,
I couldn't say either, but
I certainly tried in excess of 100 cases. And the majority of those, I would say the vast majority of those, I want to say my judicial application says maybe about 70% of those are jury versus jury waived. So that was done a while ago. I'm going to say jury
must have
trial.
judges out there that you get more jury waived out of that.
Perhaps. But I would say certainly 75 plus. That's probably a conservative.
What was the last time you did?
A couple months ago, I did a case, actually, it was a case that Attorney Bernard made reference to. Some of you may not know, Attorney Bernard is the leading defense attorney in the state on the Commonwealth versus Ananias matter. This was an individual.
He's done an incredible job.
Yes, he has, yeah. This was an individual that was part of that consolidated Ananias case.
He's driven my friend Judge Brennan crazy.
I'm sure he has.
I want to check myself and see
I
what
actually,
I'm thinking.
when I put up the proposed settlement, I actually asked him, are you gonna read that before you sign it?
Right.
They can sign it right away.
But in that particular case, as part of that consolidated case, there was an individual from Springfield that was in there. And I think, honestly, I think it was a case where the individual had run out of money, had run out of some patience, and decided to take himself out of that case. I actually, at the urging of Attorney Bernard, I actually represented that individual pro bono. We had a jury trial, and he was found not guilty. To me, one of the most
I have a
satisfying.
case that's still in there, I've already gotten not guilty on this, never been taken.
Well, that could be. That could be. But I have to say, one of the most satisfying things for me is as we walked out of the courtroom, he said to me, and I was going to plead guilty. And that made me feel very good that I think the right decision was
How many civil trials have you done?
civil.
You know that when you first get on the bench, they dump all the civil.
Right.
You know that's coming, right?
Yeah, I'm sure it is. I'm going to say 40-ish, 40 to 50 maybe civil trials. Some in Superior Court, some in District Court.
How many Superior Court trials?
On the civil or criminal?
That's not criminal.
Not a lot. Certainly the vast majority of my practice is focused on District Court. I'm going to say 15 maybe, somewhere around.
That's a lot. For most of the people that we've had come.
Right.
Actually, but, okay, I don't have any other question. I have one other issue I want to raise with you. You said that you had 3 daughters. I only counted 2.
The other one is in Arkansas.
Okay.
She was home for Christmas.
And should I ask you the question that your younger daughter wanted me to ask you?
You're going to ask it anyway, so go ahead.
Who's your favorite daughter? You don't have to answer that.
I'm going to follow the chair.
I would up as an observation, as a judge who was in Western Mass for almost 20 years, the number of times that I could count in Western Mass a serious drug case or somebody got a rifle to shoot. And just
There are some VA offices in Massachusetts that have a policy with certain types of charges that they automatically file.
And that's just not the way it's done.
And it shouldn't be the case.
Should be, that's right.
I think Spring.
And just to follow up with that, you also end up with a situation, touching on what Council Doolittle said, where, you know, judges feel like they have to do something, so they end up putting conditions on people just because they want. And sometimes those conditions can be oppressive too. Just keep that in mind. Thank you.